2018. The mother, she said the mother knew, but she didn't make a report to the police at all in the past 3 years. How is that possible? There is no medical record from the hospital. How is that possible? So on one hand, if the father has actually done as alleged, then what has the mother done as a witness of your child being assaulted by the person she is supposed to trust the most? How about the grandparents who just sit there, watch that, and do nothing? The girl also said that. But on the other hand, if the father didn't do it, if that's true, then what triggered the girl to say all these things? What is the actual domestic problem in this family? I was really upset today just thinking about these questions. Although they are not part of my duties as a defense counsel for the father's criminal investigation, and they might be relevant to the divorce upcoming, but not necessarily. But then there are things like that that make you think and reflect on what has gone wrong in our society. I think there are the father says there are some mental issues with the mother. There has been some mental problem with the girl, but neither of the parent has taken the girl for psychiatric counseling or treatments. What is wrong with these people? I don't understand that. To me, none of these should happen, but they still happens in reality. And it makes you think what has gone wrong in our society. Okay? It's too heavy for the second part. And the second part is really quick. On hate convention, it is part of the materials under the children chapter. It's, if I remember correctly from the course manual, it's really brief, and it only recites the articles for you, without really telling you much about it. Okay, so I will give you a brief introduction. I think for your exam purposes, you will want to know that there's this thing called the Hague Convention targeting abduction cases. But I don't expect the exam to go that detailed, okay, based on the course manual. And in fact, I have not actually done a Hague Convention myself from start to end, and it's a little bit unknown. I don't think it's complicated, but part of the procedure is not well known, because somehow it involves the DOJ, and on the administrative side it's just not very clear. So I try my best to explain that to you, see if you can understand. The DOJ actually has a website that introduces this Hague Convention scheme. So you might want to take a look later if you don't quite get it today, okay? The Convention on the Civil Aspects of International Abduction was signed in Hague on the 25th of October 1980s, and we usually just call it the Hague Convention. The Hague Convention was incorporated into the laws of Hong Kong by virtue of the Child Abduction and Custody Ordinance, Chapter 512. Okay. It took effect in September 1997. The relevant part of the convention, not the entirety of the convention, was adopted in Hong Kong, which you can find in Schedule 1 of this ordinance. Okay. Now, basically, the Hague Convention is an international treaty on child abduction, and if you are a contracting state, then you have to observe those provisions in the treaty. For the contracting parties, the states, you can refer to Chapter 512, capital A, the subsidiary rule to this ordinance, and you can find that Hong Kong is a contracting party.
Many of the Commonwealth jurisdictions, are contracting states to this convention, such as Canada, such as the UK. But China is not a contracting party. If a child is abducted from China, mainland China, to Hong Kong, then this ordinance is not applicable. So in that case, the applicant might have to consider worship. Okay, remember, worship is to fill the gap. When you run out of tricks, you consider worship. If a child from Hong Kong is abducted to the mainland China, there isn't much you can do either. The ordinance is not applicable either. Okay? And even if you have a Hong Kong order saying that you can't remove the child without leave, or an order from Hong Kong that the child shall return to Hong Kong, can't do much to enforce it if the child has been abducted into mainland China, because the order might not be recognized there. Okay, so if a child is abducted from Hong Kong to China, I think the best thing you can do is to seek legal advice in mainland China and take up proceedings there. Okay. The objective of the Hague Convention is basically to provide for a uniform international machinery for tracing abducted children. It is for securing the prompt and safe return of children who have been wrongfully removed from a contracting party to another, and to ensure the rights of custody and access under the law of one of the contracting state are effectively respected in other contracting states. Okay. It's an international network for protecting children who are wrongfully removed or retained. But it's only for those states or places such as Hong Kong who have signed up for that convention, not including China. The requirement, if you want to initiate an application under Hague, then you need to satisfy these 4 conditions. That the child is under 16, the child was habitually resident in the requesting state before the removal or retention, the removal or retention was in breach of the right of custody of the applicant, and that right of custody was exercised by the applicant at the time of the wrongful removal or retention. Okay, very straightforward. In this case of LCYP and JEK, the wife, the mother, is a Hong Kong Chinese born, and she grew up in Hong Kong. The husband, the father, is an American, born in Brooklyn and grew up mainly in New Jersey. They met in 1994 in Hong Kong and married in 1997 in New Jersey. After their marriage, the wife, the mother, moved to live in New Jersey, where the party set up their home. And then the wife acquired US citizenship about February 2004. There were 2 children of the family, both of whom were born in New Jersey. The family lived there until the wife moved to Hong Kong with the children in July 2013. And shortly after the wife moved to Hong Kong with the children, she discovered that her husband was having an affair. So in 2014, she petitioned for divorce in the Family Court of Hong Kong, and the husband subsequently, very shortly after, issued divorce proceedings in New Jersey. And then there are some challenges on jurisdiction and forum. In these proceedings in Hong Kong, the wife applied for joint custody so can control of the children under the GMO. She also applied for the children not to be removed from the jurisdiction of Hong Kong without leave of the court. But on the other hand, the husband took out a Hague application alleging that the wife has wrongfully retained the children in Hong Kong. One of the requirements is habitually resident for the children. So you have to, in this case, the court has to ascertain where the child was habitually resident prior to the removal. Whether it would be, well, prior to the alleged wrongful removal or wrongful retention. In this case, in the end, the judge ruled against the husband in his Hague Convention, and the husband appealed. The Court of Appeal discussed habitual residence in the context of Hague Convention. Now, in short, the CA says that habitual residence is a matter of fact. So you understand that based on the facts without any clause with legal concepts. The court would ask whether the residence of a particular person acquired in a particular place has the necessary degree of stability to become habitual. And the concept corresponds to the place which reflects some degree of integration by the child in a social and family environment. Okay, I will jump to the next slide. The question is the quality of the child's residence. How long is he there? What are his living conditions? Is he at school, at work, and so on? What is the reason for him being there? And what is his perception about being there? There is no rule that says a child automatically takes the habitual residence of the parents, but parental intent in relation to the reasons for a child's leaving one country and going to stay in another is relevant. In this case, the judge was actually satisfied that the children were habitually residents in New Jersey. Okay. The judge was also satisfied that the wife has wrongfully retained the children in Hong Kong, and that was in breach of the husband's rights of custody under the law of New Jersey. But so it seems that all the conditions here are satisfied, right? But the judge rejected the Hague Convention because, as you will see later, one of the defenses is that the court has to consider the children's view, and in this case, the children objected to return to New Jersey. And given their age and maturity, the court finds it appropriate to take into account their views. Okay, so that's why the application for return of the children was refused. Actually, the 4 conditions were satisfied in this case. Okay. What you will find as a matter of law in LCYP are some criteria for finding habitual residence. Okay, which is one of the conditions. Okay. Right of custody and access. So remember, in the 4 conditions, you have the applicant has the right of custody, and then the removal is in breach of that right of custody. The term of custody in Hague context is different from how we usually understand custody in a normal children's situation that we talked about last class. Under Article 5, which you can find in Schedule 1 of the Ordinance, the rights of custody shall include rights relating to the care of the person of the child, and in particular the right to determine the child's place of residence. And there is also right of access, which includes the right to take a child for a limited period of time to a place other than the child's habitual residence. So if you think very carefully, there are actually two levels that you have to consider. Firstly, what rights does the respondent have under the law of the state in which the child was habitually resident immediately before the removal or the retention? And secondly, do those rights amount to rights of custody under the Hague Convention? Or is the rights of applicant? So, in simpler terms, if I'm thinking of making a Hague application, I have to think, what rights do I have as, well, for instance, a parent of the child, and secondly, whether those rights would qualify as rights of custody under Article 5. Okay? So defense, the burden of proof is on the applicant to establish the four requirements. And once that burden has been discharged, the defendant or the respondent has to prove that there is a defense under Article 13. The defense can be that the applicant is not actually exercising the custody rights at the time of removal or retention, or the applicant has consented to the removal or retention, or there is a great risk that the return of the child would expose him to physical or psychological harm. Okay, or otherwise in an intolerable situation. And third, if the child objects to being returned, and if the child has attained an age and a degree of maturity at which it is appropriate to take account of his views. So that's the situation in LCYB. These are just common sense. I hope it's easy to understand. Now, here's the part that got me confused. The application for assistance, the application should be made to the central authority of the child's habitual residence or the central authority where he is now. The central authority of Hong Kong is the DOJ. The DOJ will assist in securing the return of a child wrongfully removed or retained to the place of his habitual residence if the child is under 16, if the place of the child's habitual residence before the removal was Hong Kong and the child has been removed to a contracting state, the second requirement. In that case, DOJ would help you liaise with the central authority with that contracting state for assistance in securing the return of the child. So that's when a child has been abducted outside to another contracting place, and he was originally a habitual resident in Hong Kong. In that case, DOJ would help you liaise with that jurisdiction. That's all they can do. It seems that the main focus of those proceedings would have to be in that overseas jurisdiction, not in Hong Kong. the child is not here. And if the place of that child's habitual residence before the removal or retention was a contracting state overseas, and then the child has been removed or retained in Hong Kong. So the child has been abducted into Hong Kong. Then you should apply through the central authority of the place of the child's habitual residence for assistance. So you ask for assistance overseas. And the DOJ here in Hong Kong will liaise with that overseas central authority on obtaining relevant information and evidence and assist in the judicial proceedings here in Hong Kong. Confused enough? I don't know what exactly they will offer to do. I don't know. It seems that their assistance is for gathering evidence, helping in the procedures if it is in Hong Kong, and perhaps it can help on telling you about the law in a contracting party that is relevant to the case. And when you want to apply for assistance from the DOJ, you need to provide some information of your identity, the child's identity, and the identity of that respondent or the defendant who has removed or retained the child. You need to set out the ground you rely on for the return. The child, the date of birth, and information on where the child is and whom you think the child is with currently. And you may supplement that application for assistance by an authenticated copy of any decision or agreement or an order, I suppose, a certificate or affidavit emanating from a central authority concerning the relevant law of that state and other relevant materials. Okay, I haven't, as I said, I haven't really handled a Hague Convention application before, but I've heard from friends who work in specialized matrimonial firms. It's a little bit there's a little bit of nuisance because you would have to deal with that body of central authority as under DOJ. So it's not like when you can just apply to the court in this in this course. Okay. It's not very straightforward and it's not very transparent in the sense that you don't exactly know what they're doing, what you are supposed to do for the application for assistance. The actual application of under Hague Convention takes place at the CFI of the High Court, which has the jurisdiction to hear an application under the Hague. The application has to be made by way of an originating summons in a particular form, in a expedited form, and because of urgency in a potential abduction matter, the court is expected to deliver a decision of Hague within 6 weeks. If that is not done, then the applicant or the central authority, the DOJ, may request a statement from the court explaining the delay. I have heard that this would not happen in reality. The court is too busy to meet that 6 weeks deadline. But that's the article you're supposed to observe under Article 11 in Schedule 1 of the Ordinance. And in my understanding, although this is not absolute, as you can see from the wordings, I think the proceedings would take place in the jurisdiction, which is a contracting party, where the child is currently living and staying. So if the child is abducted into Hong Kong, then I think the proceedings will be in Hong Kong. But if the child is currently overseas, having been abducted, I'm not sure if we can have these proceedings here in Hong Kong. It doesn't appear to be like that. The court, with an application, the court can make orders for security of the welfare of the child. Section 7. Section 15, the court has the power to make a location order for requiring a person or a public officer to provide the court with applicable information about the child. So you can locate the child with the help of a supposed police officer. The court may also order a person to return the child, where the court can authorize a public officer for the purpose of recovering that child. There is also Article 16, which I did not set out here. But basically, it says that a decision concerning the return of a child is not to be taken as a determination on the merits of any custody-related issue. That custody disputes should be left to the court in the place of the child's habitual residence. So if there is a divorce proceedings, the High Court should deal with Hague first. For the time being, it should not decide on custody issues, and no custody order should be made. Okay, I don't know how this operates in reality, but I hope that you have some basic idea of this regime under the Hague Convention. Okay. There isn't much hint from your course materials. That this is as best as I can understand what Hague Convention does. Okay, this is the last slide. Do you have any question on domestic violence or Hague Convention for today?
Is there any actual case for this application? For the application of the Hague Convention?
Yes, there are a few, and well, the case I cited for you is one of that cases. I haven't done thorough research into Hague Conventions, and I haven't really handled one myself. So I know that it can happen when the child is in Hong Kong and there's a Hague Convention. But then, as I said, I'm not sure if the child is not here, what the court in Hong Kong can do. Because even if you make an order here, then does it really bind the courts overseas? Is it really enforceable overseas? Because the wordings of Hague does allow for that possibility. There is room for you to make that application even when the child is overseas. But I'm thinking more practically, how is it being done? And I'm not sure. If you're really interested, call the DOJ. They might give you an answer. I've looked into their website, but it's not very clear as to what they offer to do. They're there to assist anyways. They don't, in my understanding, they don't act as your representative in making these applications. They're there to ease the procedure for you, and if there are certain enforcement issues as between jurisdictions, then they might be able to help in that regard. Okay, but in your course manual, it doesn't expand on any of those things. It only quotes some of the articles, I think. And be careful, not all the articles are the law in Hong Kong. You have to go to Schedule 1 of the ordinance. Okay, so if you rely on your course manual for your studying purposes, make sure that you cross-check with the ordinance itself, because not all of it has become the law of Hong Kong. Okay, but I don't think it would go that far. In my assignment, you might want to consider the Hague aspect. For question 3, you don't have to go into too much details. It only asks you what the wife should do. So just set out the basic procedure and the things that you should be mindful of. I don't expect you to analyze that third question as much as question 2. Okay? Just to say that what mechanism is available, what she needs to do for that plan for immigration. And on that assignment, on that note, for question 2, now when I set that question, I think it was very straightforward and easy. And I appreciate that it might not be that easy for you guys. The hints I will give you, because if you look at that question, it says that Phyllis wants sole custody and sole care and control of the children, right? And it asks you whether she can get that. So for custody, you know there's sole custody and joint custody. Care and control, there's sole, there's shared, there's joint. Right? So you have to show that you are able to distinguish those concepts as a matter of concept. And if you pay attention to my lectures, you would know that normally there would be no difficulty in finding a joint custody. So you have to consider whether there is anything in this case in particular that would justify a sole custody order in favor of Phyllis. Is there any real problem with Derek that is not suitable or capable of exercising his custodial rights? Okay, so you have to analyze the relevant factors for that. Okay, and it's the same for care and control. There should be very little controversy on custody. Okay, by now you should know what my personal preferred answer is. Even if you say that, even if your answer is different from my suggested answer, you won't be punished for that. The key is that you have to show me why you think that would be the case. So just once you have demonstrated you understand the legal concepts, apply your common sense and tell me why you think in this case it will be sole or joint custody. And it's the same exercise for care and control. I think you would spend more time or words analyzing whether it will be sole care and control, joint or shared care and control. Okay, because that one is more up for debate compared to custody. Okay. And care and control, of course, you have different relevant considerations, such as those factors in the welfare checklist, which you're free to consider. You're free to consider factors that are not in that list. Okay, whichever care and control order you think is right, you have to analyze the factors which you think are relevant and tell me why. Okay, so it can be sole, it can be joint, it can be shared for care and control. I have suggested my answer, but that's not the only correct answer. Okay, is it clearer now? So you analyze the factors, you know the law, you analyze the factors, and you tell me, by applying your understanding of these concepts and then considering the circumstances of the cases, which order you think is the most likely in this case. Does it help? I've given away so much of this already. You should be able to get a merit at least. I know that you have a word limit of 2,000. Is it the situation where you have a box on your computer and then you can't physically type over 2,000, or it's just that you have to include how many words you have? Okay, so what if you go beyond 2,000? It depends on me, because I'm not sure if I have to observe that rule very strictly. I have told of some tricks that some of you use by using footnote, and that is allowed by other. I don't want to ask space about that question, as if I'm helping you get your way out from that rule, because it's a rule set by space, it's not set by me. Personally, I have checked my answer, it's over 2,000, slightly over. But my answer is really comprehensive, and it's a very practical it's from a practitioner point of view, so I jump right to the issue. The presentation might be different from yours. So once you have that, you will see how I think about these facts. Okay? But I don't think you can, it's very unlikely that you can write a complete answer like mine. Okay, how about that? Just because I have more experiences from my practice, so I know what factors to look at. Okay? If you just give me the law and then a list of factors, and for that question alone, then the best I can do is to give you a pass. Because I really want to see how you analyze the facts. Okay? Knowing the law is important. It's a very basic, but you have to apply the law to the facts. Okay, I think that's enough hints for that assignment. Do you have any questions? I think I also talked about question 1 already. Do you need more clues? Because if you haven't really looked into the question, then you might not realize that until you actually do it. Obviously, I can't tell you the answer. But if you can attempt or think about it before we finish the last lecture on the 10th, and if you have any question, like if you don't really know how to approach that question, how it should be answered as a matter of structure, you can come ask me in person. Except that I can't tell you the answer, which I've told you enough of. Okay? On next class, it's Wednesday, right? It's 2 days from now. We will be starting on finance. Okay? Nothing more on custody and children except your assignment. So next, on Wednesday, I will give you an overview of finance, and then the next Wednesday, we will go into more details of those into that frameworks. And then we will have a class on ADR, and then the third lecture on finance. Have I told you about the mediation? Have I told you about the demonstration? Did I talk about it at the beginning? I forgot already. No? I haven't told you about this? Oh, this is really exciting. So on the 3rd of January, I remember you have a deadline. If you need to use that time and you still have your chance, that 3-class chance to skip the class, you can skip the class. I think your course manual in any event would do the justice for you for exam purposes. The slides, I hope they can help. They're very straightforward. ADR is something that it's easy to read, but it's difficult to understand by purely reading. So I have suggested a few times to have a mock mediation, and I was very excited that 2 of your classmates have actually agreed to volunteer to demonstrate for you, okay, a mock mediation. So what will happen on the 3rd of January? I might have a little bit of conflict, meaning that I'll be slightly late. I'm not sure yet. If I will be a little bit late, then I will let you know in advance. But anyways, the lecture, I hope it will be very short, because it's a lot of conceptual stuff. It's quite abstract, conceptual. It'll be really boring if I go beyond an hour or an hour and a half. So the lecturing part will be very short. And after we take a break, we can have your classmates to act as husband and wife, personally, not as lawyers. So they will try to demonstrate an opening in a mediation session. I'll be acting as the mediator, so I will first do an opening. They will each respectively introduce their case. So me as the mediator, I will try to, as you will learn in ADR, I will reframe their case so you can get a feel of what mediation is supposed to be, unlike a litigation. Okay, I have instructed the actors to be as emotional and enraged as they want with their soon-to-be ex-spouses, just so that you can have a contrast, okay, between litigation and settlement. And then I'll see how things go. It will start with a joint session, and then we'll pretend that we're doing private session. And so I hope you can see a little bit of see a little bit of my negotiation skills, maybe, because I'm not a mediator, but I've seen mediation. I've been in mediation, I've seen mediators doing their works to help the clients achieve settlement. So I hope it can give you a taste of it, right? I have prepared some facts for the purpose of mediation only, so that they have a case. It's a case on finance only, so they will settle on the money issue. This session will be after the first 2 classes of finance. So in those facts are prepared, which I will also upload by the end of this week. I have basically worked out the finance proposal for both parties. So I hope that after the 2 classes on finance, you can start to see how these factors come together in formulating a proposal on finance. I will explain to you in the class to see how I come up with the numbers. And it is a relatively easy situation where you get to share the properties of the parties instead of looking at the needs and do a different kinds of more difficult calculations. So I think it's also nice that I can use that occasion to demonstrate an exercise on finance, because the assignment is on children. So at the end, when you get my answer, you will see how I tackle a children problem in reality. Because I think in your exam, the best they will ask you is that what factors you will consider, what orders are available. They probably won't ask you which order the court is likely to order. Yeah, I think that's a bit more, it's a bit too much for this course. But I think for you to really appreciate how these things, you will need that extra booster. Okay, so just to have a sense of it and see if you can understand. I can do the calculation here on the board, and hopefully you understand how LKW and DD is to be applied in a real case. Okay, I hope it might add confusion to you. I hope it doesn't, because it can be difficult. Okay, when you're very green to matrimonial law. And I think finance the more difficult law you would have in family. Okay? So in those facts, you would have my formulation on finance for both parties. And I can tell you already that neither of these proposals will be actually ordered by court. The likely result is somewhere in the middle. Okay, so I've made the easiest scenario for these purposes, for the purposes of doing this mock mediation. So I think it would reinforce your understanding in finance, and then you have the benefit of witnessing a mediation, I hope. Sounds very attractive, right? I hope you come. But if you don't, it's fine, because this demonstration is obviously not examinable, but the third class on finance is examinable. So that's why we do the switch. Okay, so we don't have a third finance lecture on the 3rd of January. So right now I have one pair of divorcing couple. If more of you are interested in trying out this demonstration, for which you really have to be committed, okay, then come approach me with a partner. Then I will see if I can squeeze in another round. It doesn't have to be mediation, we can do FDR. Or I can make you do a court opening. Any questions? It's just housekeeping matters. Okay. I think the lectures on finance would be a little bit longer than those on children. I will try to make it as non-boring as possible, okay? Money is probably more relevant to you all. Okay, that's it. I'll be staying behind for maybe another 15 to 20 minutes. So if you have anything to ask, you can come find me. Okay, I'll be here until you're all gone. Thank you. See you on Wednesday.